Thank you for selecting the Commission on Sentencing's Sentence Risk Assessment Instrument module. This module focuses on the policies adopted by the Commission and will overview the following topics. First, we'll highlight some of the sentence risk assessment standards, covering information specific to the effective date and offenses the sentence risk assessment applies to. Next, we will overview procedures for the sentence risk assessment, which includes how the assessment is generated using the Commission's online sentencing software, otherwise known as SGS Web. The third portion of the module will discuss the Commission's recommendation based on the assessment. And finally, we will make note of best practices for successful implementation of the assessment into existing county processes and procedures. As noted, the following information is intended to highlight important policy and process takeaways to assist counties in successful implementation. More detailed information on the Commission's mandate, Act 95 of 2010, and the years of research and development can be located on the Commission's website under the Guidelines and Related Statutes section, or by contacting a member of the Education and Outreach Unit. Sentence Risk Assessment Standards. This portion of the module will cover two important questions. One, when did the assessment become effective? And two, what offenses does the assessment apply to? Please keep in mind, like the sentencing guidelines, the sentence risk assessment is prospective, meaning it applies to offenses committed on or after its effective date. The sentence risk assessment became effective on July 1st, 2020, and thus applies to offenses committed on or after this date. The sentence risk assessment applies to sentences for non-DUI individuals who pled guilty or nolo contendere to, or who were found guilty of felonies or misdemeanors. The sentence risk assessment will be calculated based on the most serious conviction offense of the judicial proceeding, in other words, the sentencing hearing, and will be generated one time for each judicial proceeding, again, based off the most serious offense. We have provided an example to illustrate the concept of most serious offense of a judicial proceeding. In this example, an individual is before the court for sentencing on the same day for 3 separate dockets representing 3 conviction offenses. The Commission's sentencing software is based on the sentencing date and considers this to be a single judicial proceeding, regardless of the number of dockets. As you can see, the grading of the offenses varies from the least serious being an ungraded misdemeanor and the most serious being a felony 3. As we have indicated, the sentence risk assessment will be calculated based on the most serious conviction offense in the judicial proceeding. In this scenario, the assessment would be generated based on the felony 3 conviction. As noted, the sentence risk assessment applies to non-DUI offenses. For example, if an individual is in front of the court for sentencing and the most serious offense of the proceeding is a DUI, the sentence risk assessment instrument will not be generated. Furthermore, and consistent with the sentencing guidelines, the sentence risk assessment does not apply to the following dispositions: accelerated rehabilitative disposition, ARD, disposition in lieu of trial, direct or indirect contempt of court, violations of protection from abuse orders, or revocation of probation, county intermediate punishment, state intermediate punishment, or parole. Sentence risk assessment procedures. Now that we understand when the sentence risk assessment became effective and what offenses it applies to, we can overview how the information is generated. How do we generate the sentence risk assessment? This is a great question and has been a significant part of the Commission's work. It is important to note the court is required by statute to consider the sentence risk assessment prior to sentencing. A concern during the development of the sentence risk assessment was the potential impact it might have on existing county workloads. To assist in alleviating additional burdens on those working within the system, the Commission incorporated the sentence risk assessment into its SGS Web application to leverage existing information and generate the recommendation. This process relies on variables obtained from AOPC and Commission data found to be significantly associated with recidivism. Because of concerns raised during public hearings, the Commission relies on conviction data rather than arrest data. Listed on the screen are the 7 factors included in the sentence risk assessment and the associated application for which the data is obtained. Data for 5 of the 7 factors is obtained from the Commission's SGS Web application, and data for the 2 remaining factors from AOPC. When the risk assessment module is deployed in SGS Web, a risk assessment will automatically be generated during the preparation of the sentencing guidelines. For process specifics related to SGS Web, please contact the Education and Outreach Unit and check the Commission's website and YouTube channel for future SGS Web instructional videos. Sentence Risk Assessment Recommendation. At this point, we have covered fundamentals regarding when and how the sentence risk assessment is completed. With that established, let's discuss the sentence risk assessment's recommendation to the court. As noted in the prior portions of this module, the sentence risk assessment is generated based on the most serious conviction offense in the judicial proceeding and does not apply to DUI offenses if the DUI offense is the most serious in the judicial proceeding. The sentence risk assessment instrument identifies 3 categories of risk: low, typical, high. For individuals who are identified as typical risk, the Commission makes no additional recommendation to the court. For individuals who are identified as low or high risk, the guideline sentence form will include a notation of additional information recommended. Because of concerns raised in public hearings about the labeling of individuals, no information on the risk category, for example low or high, will be provided. Similar to the sentencing guidelines adopted by the Commission, a recommendation to obtain additional information based on the sentence risk assessment instrument is advisory. The additional information recommended may assist the court in determining an appropriate and individualized sentence, including the suitability of various sentencing alternatives and programs, as well as the duration and intensity of supervision. Because additional information may impact the processing of the case and the sentence imposed, courts are encouraged to adopt procedures to ensure the identification of cases for the preparation of additional information prior to sentencing. In every case in which additional information is recommended, the court is required to make as part of the record and to report to the Commission through SGS Web whether the court received and considered additional information prior to sentencing. As part of the implementation of the sentence risk assessment policy, the Commission conducted a 6-month training and orientation program for judges and practitioners, including a request to meet in each of Pennsylvania's 67 counties to review the purposes and procedures and to discuss local processes. We recognize the potential impact of introducing a new practice into existing procedures and have worked to program SGS Web to assist in the efficient and timely generation of the assessment. That said, individual county court systems should review their current practices as it relates to the use of SGS Web, specifically on the timely generation of sentencing guideline forms prior to sentencing. For the sentence risk assessment to be generated prior to sentencing, cases must be created in SGS Web as early in the process as possible. As of the beginning of July 2020, staff have met with nearly 45 counties to discuss this very subject. Through our discussions, we have found many counties are well situated to implement the sentence risk assessment into their existing process, though numerous counties have made noticeable changes in their use of SGS Web. In certain instances, it required departments not historically engaged with the use of SGS Web to recognize their unique position to assist in successfully implementing this process system-wide. Since the sentence risk assessment can only be generated through SGS Web, it is important that local processes address the use of SGS Web to assure the preparation of the sentencing guidelines and consideration of the sentence risk assessment recommendation prior to sentencing. Failure to do so is in conflict with the statutory requirements and may impact compliance with the guidelines. Staff are committed to assisting counties in reviewing their current practices and use of SGS Web in order to highlight processes established by other similarly situated counties. If you are interested in meeting with staff, please contact the Education and Outreach Specialist in your region to coordinate a meeting. In summary, we have overviewed certain standards, procedures, and recommendations related to the Commission's Sentence Risk Assessment Instrument. In addition, best practices for timely generation of the Sentence Risk Assessment Instrument were discussed. As a reminder, the Sentence Risk Assessment Instrument became effective July 1, 2020, and applies to offenses committed on or after this date. Staff anticipate the Sentence Risk Assessment module to be deployed in SGS Web in September 2020. As with all of the Commission's trainings and seminars, we value your feedback. Please feel free to submit comments or questions via email to Ryan S. Myers, Manager of Education and Outreach. Contact information for Ryan, as well as members of the Education and Outreach Unit, can be found as part of this module or by visiting the Commission's website at pasentencing.us. Thank you for taking the time to view this module, and have a great day.